Today, we will discuss the complex topic of structuring multiple business ventures under a single holding company. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, as well as a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my law practice. My firm website is www.cummings.law, not .com, but .law. When structuring multiple business ventures, the concept of a holding company often emerges as a viable and, in some cases, lucrative option. A holding company is a parent corporation or limited liability company that owns enough voting stock in another company to control its policies and management. It does not produce goods or services itself. Rather, its primary purpose is to own shares or membership interests of other companies. This structure can provide significant advantages, including risk management, tax benefits, and simplified management. However, the complexity of establishing a holding company should not be underestimated. Many entrepreneurs mistakenly believe that creating a holding company is a straightforward process. In reality, the intricacies of corporate law and tax regulations necessitate the guidance of an experienced attorney and CPA. These professionals working together can navigate the legal requirements and ensure compliance with state and federal laws, which is absolutely crucial for the successful operation and continued viability of the holding company. The holding company structure offers several benefits for entrepreneurs managing multiple business ventures. One of the primary advantages is liability protection. By separating or segregating the assets of each business entity under the umbrella of a holding company, owners can protect the assets of one business from the liabilities of another. This separation can be crucial in industries with high risk exposure, such as real estate, energy, oil and gas, tech, you name it. There are very few industries, segments, and verticals which would not benefit from proactive liability segregation and separation, especially that provided by a holding company structure, such as the one that I'm describing. Another significant advantage is tax efficiency. Holding companies can, when formed and managed correctly, facilitate tax planning strategies that minimize the principal's overall tax burden. For instance, dividends paid by subsidiaries to the holding company may be tax-free in certain circumstances and depending upon the jurisdiction. Additionally, the holding company can leverage losses from one subsidiary to offset profits from another, at least in certain circumstances, thereby reducing taxable income, although it is important to note out that the Federal Internal Revenue Code has very complex rules, which are called passive activity loss rules and loss limitation rules. So this can be a very tricky area depending upon your particular segment or vertical. These strategies do require careful planning and execution, underscoring the necessity of competent professional advice from an attorney and CPA. Forming a holding company involves several legal considerations that must be meticulously observed. The first step is choosing the appropriate legal structure for the holding company itself, which, as I mentioned earlier, could be a corporation or limited liability company or LLC, or in very rare cases, a general partnership or limited partnership. Each structure has its own legal and tax implications, advantages, and disadvantages, and the choice should align with the business goals, the nature of the subsidiaries, and the objectives of the owners or principals. Furthermore, the formation process requires compliance with state-specific regulations, including filing articles of incorporation or organization, drafting bylaws or operating agreements, including buy-sell agreements and push-pull agreements, the consistent use of written consents and other strict observance of corporate governance procedures, and obtaining necessary licenses and permits. Entrepreneurs often underestimate the complexity of these tasks, which can lead to very costly mistakes. Engaging with an attorney and CPA early in the process, ideally before any documents have been prepared or filed or signed, can help to ensure that all legal requirements are met, thereby avoiding potential legal disputes and penalties, whether at that time or down the road. As I said earlier, the tax implications of a holding company structure are multifaceted and require careful analysis. This is not a cookie cutter exercise. One of the key considerations is the potential for tax consolidation, which is where the holding company and its subsidiaries are treated as a single entity for tax purposes. This can be advantageous and can simplify tax filings in certain circumstances, and as I said earlier, in certain cases, allow for the offsetting of losses and profits across the group, though again, that is a complex area of law and is not guaranteed, certainly something to discuss with your attorney and CPA. However, achieving that tax efficiency through a holding company structure is not without challenge. It requires a thorough and complete understanding of state and local tax laws and regulations, including those related to transfer pricing, cost segregation, intercompany transactions, and international tax treaties if the subsidiaries operate in other countries. An attorney and CPA can provide invaluable assistance in navigating these nuances and complexities, again, helping to ensure compliance and optimizing the tax position of the holding company and its subsidiaries and owners. A holding company structure can enhance operational efficiency and management control across multiple business ventures. That is, by centralizing strategic decision-making and administrative functions at the holding company level, entrepreneurs can streamline operations and reduce redundancies. This centralized approach can lead to significant cost savings and improved resource allocation in some cases. Moreover, the holding company itself can implement top-down uniform policies and procedures across its subsidiaries, ensuring consistency and alignment with the overall business objectives. However, achieving these benefits requires careful planning and coordination. The expertise of an attorney and CPA is essential in designing an effective governance framework and establishing clear lines of authority and accountability within the holding company structure down to the subsidiary level. Despite these advantages, several misconceptions about holding companies persist among entrepreneurs. One common misconception is that a holding company automatically guarantees tax savings. While potential tax benefits do exist, they are not automatic and depend upon the specific circumstances and implementation of tax strategies. Another misconception is that holding company, or rather the usage of a holding company, is a one-size-fits-all or cookie-cutter solution for managing multiple business ventures. In reality, the suitability and feasibility of utilizing a holding company structure depends on myriad factors, including the nature of the businesses, the industry, vertical, the long-term objectives of the entrepreneur, succession planning, and myriad other factors. I said myriad, but I'll say it again because it's a great word. A thorough analysis of an attorney, or rather by an attorney and CPA, is necessary to determine whether a holding company is in fact the optimal structure for a particular business scenario, or whether another approach is indicated. The involvement of an attorney is crucial in structuring a holding company. Experienced attorneys bring a wealth of knowledge and experience in corporate law, LLC law, corporate governance, securities law, tax planning, and financial management. They can assist in evaluating the feasibility of a holding company structure, preferably, again, as I said before, any documents have been signed or filed, selecting the appropriate jurisdiction, selecting the appropriate legal entity, and ensuring compliance with regulatory requirements. Furthermore, an attorney and CPA working in unison can provide ongoing support in managing the holding company and its subsidiaries. This includes advising on corporate governance, preparing for or responding to audits or requests for audits, whether by stakeholders or the Internal Revenue Service or state taxing authorities, and implementing tax strategies. Their expertise is indispensable in navigating the complexities of a holding company structure and in maximizing the benefits for an entrepreneur. Establishing a holding company involves several key steps that require intricate planning and execution, as well as consistency. The first step is in conducting a comprehensive analysis of the existing business venture. That is to say, if there's only a single operating company or multiple subsidiaries, and deciding if and how those should be consolidated or grouped, and determining the objectives of the holding company and its owners. This analysis should, as I said earlier, consider factors such as risk management, tax efficiency, operational control, and other factors. Once the objectives are defined, the next step is in selecting the appropriate legal structure and jurisdiction for the holding company. This decision should be guided by an attorney and CPA, taking into account the legal, tax, and business environment of the jurisdiction. After selecting the structure, which might be a corporation or LLC, or as I said earlier, even an old school partnership in some very unusual cases, the necessary legal documents must be prepared and filed, including articles of incorporation or organization, as well as bylaws, operating agreements, push-pull agreements, written consents, several other documents as well, at least on an ongoing basis. In conclusion, structuring multiple business ventures under a single holding company can, when executed correctly and consistently, offer significant advantages, including liability protection, tax efficiency, and operational control. However, the process is complex and fraught with potential pitfalls. Entrepreneurs should not attempt to navigate this process alone. The guidance of an experienced attorney and CPA is absolutely indispensable to ensure compliance with legal and tax formalities and to minimize the prospective benefits of the holding company structure. By engaging professional assistance, entrepreneurs can confidently establish a holding company that aligns with their business goals and provides a solid foundation for future growth and success. The complexities of corporate, LLC, and partnership law, as well as the Internal Revenue Code and state tax regulations, demand a strategic, nuanced approach, not a reactive approach. And the expertise of an attorney and CPA is absolutely essential in maximizing the likelihood of a successful outcome. Again, my name is Chad Cummings of Cummings and Cummings Law, and it was a pleasure sharing this information with you today. If you have any questions regarding this or any of the other topics covered in our videos, please visit my firm website at www.cummings.law, not .com, but .law to schedule a telephone consultation. Thank you for your time, and I look forward to the opportunity to speak with you very soon.